Hi, good morning, everybody. Thanks for joining us on this Wednesday morning. We have some fun stuff to talk about, some questions that go back to one of the first issues I worked on for my HR counsel, but also a question that pops up fairly frequently um, over the course of questions that get submitted by our clients. And so I thought it would be something worthwhile for everyone to dig into and learn about. So today we are talking about sharing background checks, sharing I-9s, sharing drug test results with third parties. So a lot of times employers will get third parties that want them to share employee information with them. It could be a payroll service, it could be a client who's going to have one of your employees on site. And most commonly, I see questions about sharing I-9s and background checks. Comes up pretty frequently. And I can understand where some of these third parties get the notion that they need to know this information. It makes sense if you're sending someone out, say you're a staffing agency, you're sending temps out. If you're, don't have to be a staffing agency, you could be doing consulting, you could have somebody on site, you could be a plumber, right, and send somebody to somebody's building or office or home. And sometimes the other company or the third party wants to know more information about these workers that are coming into into their place, into their site. And so they want some more information to be sure that you're not sending a murder bot to do bad things to whoever's at that place. Other times it can come from payroll or other vendors, sometimes benefit administration. But spoiler alert, it's a big no-no, and I'm about to get into why. So first, we're going to talk about sharing I-9s. In 2013, there was a company in Alabama that asked for assistance from the United States Department of Labor Office of Special Counsel. And what you can do is, if you have a question about a law or an administrative rule or something like that, if you're not sure, you can actually write the government and ask them for an opinion on a matter. You'll see similar things, and probably maybe even more often, as it comes to things where people write to the IRS and ask for what's called a private letter ruling on a tax issue, so that they can decide which way they're going to go and how they're going to move in terms of what the answer is from the federal government in terms of how they're going to interpret the law. So back in May 30th, 2013, almost 11 years ago now, this company, Alabama, said, hey, one of our payroll providers, I think they're doing payroll cards, wants to see I-9s for our employees so that they can set them up in our system. Is it cool if we share those with them? And the Office of Special Counsel resoundingly said absolutely not. And here was their reasoning. Number one, they've cited two things in the Immigration and Nationality Act. The INA provides what the purpose of I-9s is and what you can do with it. So pursuant to federal law, a person or an entity that hires, recruits, or refers an individual for employment must verify the identity and employment authorization of each person that is hired. Thus, that's how I-9s came into existence, and subsequently E-Verify. 8 U.S.C. 1324A states that Forms I-9, quote, may not be used for purposes other than enforcement of essentially the INA and certain provisions of federal criminal law. So that language is pretty clear that you cannot share I-9s except with essentially the federal government for purposes of investigating violations of the Immigration and Nationality Act or criminal law. Second thing that the Office of Special Counsel pointed out is that they were worried that if this third party starts looking at I-9s and they say, hey, how do we know that that passport that the employee gave our client here was actually a legitimate passport? How do we know it wasn't forged? How do we know that's not a fake driver's license? And so the Office of Special Counsel went on to say, not only are we worried about, the people sharing the forms that you're not supposed to share to begin with, but they're worried about the next step is what happens if people start questioning the underlying documents that were used to verify employment on the I-9. So that in turn could result in the employer having to go back to the employee and request more and specific documents from the employee to provide to the third party. Well, this would result in a violation of the anti-retaliation provision of the Immigration and Nationality Act, cited there at the bottom of the screen. And the anti-retaliation provision does 4 things in terms of discrimination. It prohibits discrimination based upon citizenship or immigration status. It prohibits national origin discrimination. It prohibits retaliation for filing a charge or insisting an investigation about the anti-discrimination provision. And finally, and the key one here is that it prohibits unfair documentary practices during the employment eligibility verification, i.e. I-9 and E-Verify process. And that's called document abuse. And basically, in a nutshell, you can't ask an employee for a specific document or documents when they're filling out the I-9. They give you what they give you, and as long as they meet list A, B, or C, and the qualifications that you need, you get what you get, and you don't throw a fit, essentially. And so the Office of Special Counsel basically said no. In addition to that, those of you that use E-Verify have other issues. E-Verify employers that might be printing E-Verify results to share with third parties have some other concerns here. So when you sign up for E-Verify, you agree to a memorandum of understanding that you can use the information that from SSA or DHS pursuant to E-Verify only to confirm the employment eligibility of the employees authorized as authorized under the memo. And the memo says that an employer is required to ensure that the information is not disseminated to any person other than the authorized employees at the employer. Additionally, the E-Verify memorandum of understanding states that information which the employer receives is governed by the Privacy Act and the Social Security Act, and that misuse of the information will result in criminal penalties. So it's even worse if you share E-Verify results than sharing an I-9. All right, moving on to background checks and drug tests results. So we got 3 areas that are going to govern this in terms of background checks. Number 1, we have the Fair Credit Reporting Act. There are requirements for employers under Fair Credit Reporting Act, which all of you are probably familiar with. You have to, get permission in writing from your employee to run a background check. There's certain disclosures you have to give. The employee or the applicant has a right to get a copy of the report, et cetera, et cetera. So there's that half that everyone is probably here familiar with. Then there's the second half of the Fair Credit Reporting Act, which most of you probably don't delve into. And the second half governs credit reporting agencies. So when you get that background check or credit check, from Experian or whatever they're called, TransUnion, all those credit bureaus nowadays, those are credit reporting agencies that run those background checks and that run those criminal history checks and all that fun stuff. They are governed by a lot of rules within the Fair Credit Reporting Act as well. So their rules among other things, require a credit reporting agency to establish and implement written policies and procedures regarding the accuracy and integrity of information that you furnish as a credit reporting agency. And then these rules regarding that these policies that you have to have are pages long. So just the rules, in order to set up the policies, you have to go through pages of federal code in order to figure out what your policies are. And that's just, a tiny little portion of the Fair Credit Reporting Act and what is required. No employer that I know of has any of these policies in place on the employment side, let alone any of the other mechanisms required, such as investigating if there's a dispute as to the accuracy of data and all that stuff. This is exactly why we hire third parties to run these background checks to begin with. We don't have the time and expertise to deal with this stuff. And we'll get back to credit reporting agencies in a little bit on the next slide, and this will tie in, I swear. Other things you have to worry about on the state law level, you could have privacy law concerns with sharing someone's background check without their consent. People could bring a private right of action under state law to file suit there. And finally, your contract with your credit reporting agency or your drug testing company might limit what you can and cannot share regarding that information. They might say, hey, you can't share this outside your organization. So if you do share background checks or drug tests with third parties, you could be in breach of contract with your third party provider here. So on drug tests first, what happened is the FTC has issued an opinion letter. It feels weird to me saying that an opinion letter from 1998 is old, but I guess it is. I mean, it's from the last century and it's over 25 years old now. But the FTC opinion letter held that a drug test is considered to be a consumer report, and as such, it is subject for the Fair Credit Reporting Act. Then, if an employer goes on and shares that drug test with a third party, the employer then becomes a credit reporting agency under the Fair Credit Reporting Act. And the employer has to abide by all the rules and regulations of credit reporting agencies under the Fair Credit Reporting Act, which, as we talked on an earlier slide, nobody can do. Nobody does this. Nobody has the setup for handling any of that. In terms of background checks, there is no fancy opinion letter from the government on, but there is a beautiful, I guess being in the eye of the beholder, a beautiful case out of Connecticut called Adams v. National Engineering Service Corp. This case, a little newer, came down 2009, it's only 15 years old. And it's about a staffing agency. And the staffing agency was looking to fill some positions with a client. The client had some really specific background check requirements that they wanted to have met. And the staffing agency ran a background check, and they weren't sure whether or not this person, Adams, was going to meet the requirements of the background check or not. And so they shared the entire background check report with their client and let their client make the decision based upon what the background check said. Now, note that the staffing agency didn't create the background check. They didn't run the background check. They just, purchased it as a service through a third party. Adams, in this case, was denied employment based upon the background check. She sued in federal court. The background check agency and the staffing agency. And she basically said, by sharing the background check report, the staffing agency is now a credit reporting agency and has to follow all these rules, which they didn't do. The staffing agency lost that case, and this case is still good law. I've been following it for years. I get an update about once a month when somebody cites it in a brief in federal court, but it's never been overturned and actually never even been challenged since then. So net, for all of this, don't share I-9s, Don't share background check reports. Don't share drug testing reports. And so a lot of times companies say, well, what am I supposed to do? It's like, well, there's a couple things you could do. Number one, your best course of action here is to provide a client with a signed attestation that you have conducted the background check and drug test or whatever, according to the contract or agreement or federal laws that you're subject to, and that the outcomes met, the standards, either your standards internally, or if the client has standards, the client's standards. Now, it might be tempting just to give in to a client's request for background check and drug test results, but the risk of doing it just are so great compared to the rewards on this. Sometimes that doesn't always appease everybody, and so this one usually works for me. If you have a client that really, really, really wants to see these documents, you can say, we'll agree to it if their legal department will sign off on that company indemnifying you for any violations of the Fair Credit Reporting Act. Most companies are allergic to the word indemnification, so this will dry up most requests real quick. I think I've only had one company ever question my advice on that, and not my client, but the client's client, in about the past 10 years or so. Once I provided all the applicable case laws and the opinion letters, they rescinded their request and declined our offer to see them if they agreed to indemnify us fully. I'm not sure why, but I was kind of hoping that they would, just because I wanted to see them follow through on their threat to begin with. All right, that brings us to the end of today's webinar presentation. Thank you all for joining us. If you have questions, if you're clients, submit it through our portal. Otherwise, I hope you all have a great couple of weeks until we talk to you all again.